The funeral was 9 days ago. The flowers people sent are still dying in vases around this house, and I am sitting at my kitchen table staring at financial statements that explain my husband's life more honestly than he ever did. Not crying, not holding his photograph, sitting here with a calculator, a legal pad, and 4 years of records from a company Whitmore inherited and quietly drove toward collapse while I slept beside him, believing we were still living inside the same marriage. The debt is real. I found it 3 days after we buried him, not because anyone warned me, but because I am the kind of woman who opens drawers other people leave closed. Always have been. That instinct built Pruitt Facilities Solutions from one janitorial contract in 2001 into a commercial facilities company managing properties across 3 counties. Not through connections, not through inheritance, through work people considered beneath them, and I considered reliable. My name is Elowen Pruitt. I am 53 years old. I have negotiated contracts, signed payroll, managed crews, survived recessions, and handled every hard thing this life placed in front of me without collapsing publicly. I intended to handle this too. The numbers spread across my kitchen table were devastating. Whitmore's inherited company was carrying active creditor claims, vendor disputes stretching back nearly 2 years, equipment financing defaults, tax exposure. He apparently tried managing through extensions and partial payments, and 2 properties with liens attached. What made it worse was how carefully he separated everything. Whitmore's company operated independently from mine from the beginning of our marriage. Different accountants, different payroll systems, different operating banks. His father structured it that way years before I entered the family because the Whitmores treated that business like bloodline property, not shared marital infrastructure. I handled Pruitt Facilities Solutions. Whitmore handled Whitmore Industrial Holdings. We discussed broad performance over dinners and holidays the way married business owners do, but I was never inside his day-to-day books unless he invited me there. And over the years, he stopped inviting me there at all. Looking back now, I can see the progression clearly. Small comments about delayed vendor payments, frustration with tax reassessments. Equipment replacement costs, he said, were temporary setbacks. Every explanation believable on its own. Nothing dramatic enough individually to justify me forcing my way into another company's internal operations when I was already running 31 employees and municipal contracts of my own. That was how he hid it. Not through brilliance, through separation, pride, and years of accumulated marital trust. Some of the transfers moved through accounts Whitmore controlled separately from our household operating structure. That was how he hid the scale of it this long. Inherited companies create blind spots inside marriages when one spouse handles operations independently and the other is busy building an entirely separate business. I spent most of last night organizing everything into one final figure I could force myself to look at directly. The figure changed the air in the room. I sat with it until sometime after 2 in the morning. Then I made a decision the way I make every serious decision, quietly, without announcement, without performance. I would cover it. Use my company's reserves where necessary. Restructure what could be restructured. Absorb what could not. Spend the next several years cleaning up what Whitmore left behind. It was not fair. It was simply what was in front of me. That is the kind of woman my mother raised. You do not walk away from responsibility because it arrived wearing someone else's name. The marriage was not perfect. I want to be honest about that without becoming theatrical. There were silences between us that lasted too long. Trips I eventually stopped asking about because the answers became thinner each year. A version of Whitmore that began drifting somewhere around year 11. Subtle enough at first that I told myself it was business pressure, age, exhaustion. I believed the marriage was still real, even when it became difficult. I believed we were the kind of people who handled things privately and stayed. Even now, sitting at this table, surrounded by his financial wreckage. I had already decided to stay. That decision felt settled as of this morning. I poured my second cup of coffee, picked up my legal pad, began outlining a repayment structure that would redirect everything I built toward repairing everything Whitmore broke. Then I heard a car turn into the driveway. I was not expecting anyone. It was Tuesday. Clarice Dunmore had already come by last Thursday with enough casseroles to feed a church gathering. Oswald Muse and I were not scheduled to speak until Thursday afternoon. I set my pen down. The vehicle outside did not sound familiar. The engine stayed running a moment too long before shutting off. The sound of someone sitting in a parked car preparing themselves for what comes next. I stood slowly from the table. If you found this story, drop a comment and let me know where you're watching from. I'd love to know how far this has traveled. I walked to the front door and looked through the glass. There was a woman standing in my driveway, a child beside her, and a license plate I did not recognize until I focused on it properly. Ohio. She was not what I expected. I don't know what I expected exactly, but not this. Not a woman standing in my driveway at 10:40 on a Tuesday morning looking like she had an appointment. Composed, dressed carefully in a dark wrap coat, hair pulled back, posture straight. The kind of composed that takes preparation, the kind you practice in a mirror before you drive 400 miles to knock on someone's door. The child stood beside her. A boy, small for what I guessed was around 6. He was holding her hand, but looking past her, looking directly at me with eyes that stopped my breath in my chest before I could stop it myself. Whitmore's eyes. The exact shape, the exact stillness in them. I held the door and said nothing. The woman spoke first. Her voice was even, measured. She had rehearsed this too. My name is Hessie Collier. I was Whitmore's wife. This is our son, Stellan. Not his girlfriend. Not his partner. Not the mother of his child. His wife. She said it the way a woman says something she has every right to say. No apology in it. No aggression either. Just a plain declarative fact delivered on my front step like a piece of certified mail. I looked at her, then at the boy, then at the folder tucked under her left arm, thick, organized, the kind of folder you build over time. She had not come here grieving. She had come here prepared. The silence between us stretched 4 full seconds. I counted them without meaning to. You'd better come in, I said, not because I wanted her inside my house, because I needed to see what was in that folder, because a woman who drives from Ohio with a prepared child and a prepared folder on the 9th day after a funeral is not a woman you turn away from your door. You let her in, you sit across from her, and you listen to every single word she says. She stepped inside without hesitation. Stellan followed. He looked around the front room the way children do, taking inventory, not judging. His eyes moved over the furniture, the photographs on the side table, and then stopped on one. A framed photograph of Whitmore from 3 years ago, taken at a company event. The boy looked at that photograph for a moment longer than everything else. I closed the front door. Hessie was already moving toward the sitting room like she had some idea of where it was, or like she had decided that hesitating would cost her something. She chose the chair across from the sofa, not the sofa, the chair, which put her facing the room with her back to the wall. She had thought about where to sit before she arrived. I noticed that. I sat on the sofa. Stellan sat beside his mother, still quiet, still watchful. Up close, the resemblance was worse. The jawline, the way he held his shoulders. There was nothing ambiguous about this child's parentage, and we both knew it, and neither of us said it. Hessie placed the folder on the coffee table between us. She did not open it yet. I know this is not easy, she said, but Stellan is Whitmore's son, and we have rights. The word rights landed differently than wife had. Wife was a claim about her. Rights was a claim about everything. I looked at the folder, then at her face, then at the boy who had his father's eyes and no idea what his mother had just walked him into. I said, "Show me what you brought." Hessie opened the folder like she had done it before. Maybe in front of a mirror, maybe in front of an attorney. The movements were too practiced to be grief and too careful to be anger. She laid the first photograph on the coffee table between us. Whitmore, younger, maybe 42, 43. Standing outside a house I didn't recognize, his arm around Hessie, both of them looking at the camera with the easy comfort of people who had stopped performing for photographs years ago. Behind them, a front porch with hanging plants and a welcome mat. She laid down a second, then a third, a ceremony photograph. Whitmore in a dark suit I had never seen, Hessie in ivory. Stellan was not in these photographs. These predated him. A small gathering, someone's backyard, folding chairs and flowers and a man officiating from what looked like a printed page. She placed the ceremony program beside the photographs. Folded, cream paper, both their names printed on the front, then the letters. 4 of them. Whitmore's handwriting. I would know it anywhere. The way he pressed hard on every downstroke. The envelopes were addressed to Hessie at an Ohio address. I didn't read them. I didn't need to. The handwriting was enough. Stellan sat beside his mother through all of it, not fidgeting, not asking questions, watching me the way a child watches an adult when he has been told this meeting is important without being told why. I looked at everything on that table. Then I looked at Hessie. "Did he tell you about me?" I asked. She didn't hesitate. That was its own answer before the words came. "He said you were the one he couldn't leave." Her voice was even, practiced even here. "Not because he loved you, because leaving would have cost him too much. The business, the family name. He said you were difficult, that you'd spent years pulling away from him emotionally, that the marriage had been over in everything but paperwork for a long time." She said it cleanly. No cruelty in the delivery, which somehow made it worse. She wasn't trying to hurt me. She was simply repeating what she had been told and believed for years. He had built me into a character in her story. The cold wife, the difficult one, the obstacle, a version of me that justified everything he was doing in Ohio and absolved him of every choice he made in this house. I sat with that for a moment, not with rage, with something quieter and more permanent. The specific grief of understanding that the man you buried was also the man who used your name to make his lies livable for someone else. "How long?" I asked. 9 years, she said. "Stellan is 6. 9 years. I ran the timeline without meaning to. What we were doing 9 years ago. Where we were in this marriage. The trip he took to Columbus for what he called a facilities conference. The second trip. The third. Hessie reached into the folder one more time. She slid a document across the table. Face up. Deliberate. A marriage certificate. Her name. His name. A notary seal in the bottom right corner. I looked at the date. 14 years into our marriage. 11 years before he died. The room was very quiet. Stellan was looking at his hands now. Even he seemed to understand that something in the air had shifted. I finally looked up at Hessie again. "You believed this was legal," I said quietly. Her expression changed slightly then. Not defensive exactly. Careful. "He told me the divorce had already been handled privately through attorneys in Birmingham before we met," she said. "Said because of the businesses and the family name, everything was kept quiet until the financial separation finished processing." I said nothing. He always had an explanation ready whenever paperwork came up, she continued. Taxes were filed separately because of business structures. He said public records lagged behind because of interstate filing issues. A pause. I asked questions at first. And then, her eyes moved briefly toward Stellan before returning to me. Then years passed, she said softly. And eventually, I stopped looking for reasons not to believe the man I was building a life with. That landed harder than I expected it to. Not because it excused her, because I understood it, not the deception itself. Never that. But the slow human process of accepting incomplete answers when the alternative means admitting your entire life may be standing on something unstable. Whitmore had not maintained two lives through brilliance. He maintained them through distance, selective truth, and the natural human tendency to trust explanations that protect the future you already committed yourself to emotionally. I looked back down at the certificate, the notary seal, the signatures, the ordinary appearance of something that should never have existed at all. I did not pick the document up. I just looked at the date until the date looked ordinary. It never did. Hesse gathered her documents the same way she laid them out, methodically, without rushing. She slid everything back into the folder, straightened the edges, and stood like a woman completing something she had rehearsed repeatedly before arriving at my house. Stellan stood when his mother stood. He looked at me once before they moved toward the door. Not hostility, not confusion. Just a quiet child's stare at something too large for him to understand yet. I walked them out. I stood on the porch until the Ohio plates disappeared at the end of the street. Then I went back inside, closed the front door, and stood there in the silence of my own house for a long moment. I did not cry. I thought about crying, located the feeling the way you locate sound through a wall, aware of it, aware of where it lived, choosing not to open the door between us yet. Maybe not ever. Grief for a man who spent 14 years building another life beside mine required something more complicated than tears. I picked up my phone and called Oswald Muse. He answered on the second ring. I told him everything without embellishment. Hesse Collier, Ohio, the photographs, the ceremony certificate, the child. Whitmore's face looking back at me from a 6-year-old boy standing inside my sitting room. Oswald stayed quiet through most of it. When I finished, he said, "Come to my office tomorrow morning, 8 o'clock. Don't contact her. Don't respond if she reaches out first. And don't move money or documents around tonight." I said I understood. Then I hung up and returned to the kitchen table. The financial records were still spread across it exactly the way I left them the night before, but I looked at them differently now. Not as recklessness, structure. I started with the withdrawals I had already flagged as irregular during my first review. Transfers from inherited operating accounts Whitmore managed separately from our household structure, and outside the accounting systems tied directly to my company. That distinction mattered now, because it explained how the pattern stayed hidden long enough to grow. I pulled every questionable transfer into a separate column. The pattern appeared almost immediately, every 4 to 6 weeks. Consistent amounts, slight increases during holidays, larger transfers near back-to-school periods and summer months. Not random spending. Support. A second household operating on a schedule. The debt wasn't simply mismanagement. It was maintenance. 9 years, maybe more, of financing another life through accounts Whitmore controlled independently because the inherited business remained largely under his direct authority, while I stayed occupied building and expanding my own company. I worked through the night. By 4 in the morning, I had reconstructed enough of the transfer schedule to estimate what Whitmore diverted over the documented period. I wrote the number on my legal pad and stared at it beneath the kitchen light. The number no longer shocked me. It confirmed something worse: intent. I leaned back in the chair, rolled tension from my shoulders, poured a glass of water I never drank. Then I opened the final accordion file sitting untouched at the edge of the table. The tab carried nothing except a year written in Whitmore's handwriting. Inside sat a bank statement for an account I had never seen before. Not joint, not business, personal. Whitmore's name only. I studied the transaction history carefully. Most of the account activity was sparse, occasional movement, modest balances, nothing large enough individually to trigger attention if someone was scanning broader financial records quickly. Then I reached the final page. The last transfer was dated 4 days before Whitmore died. The amount moved out was substantial enough to tighten something low in my stomach immediately. Not ordinary spending. Not routine movement. A deliberate transfer. I checked the destination line again. The receiving account number was partially redacted on the statement copy, but not completely. And for the first time since Hesse Collier stood in my driveway, I felt something shift underneath all the grief and betrayal and anger. Not emotion, suspicion. I looked at the transfer date one more time beneath the kitchen light. 4 days before Whitmore died. And suddenly the timing no longer felt accidental at all. Oswald Muse's office was on the 14th floor of a building downtown that had his name on the directory and nothing unnecessary on the walls. He was that kind of man. Precise. Economy of everything. Words, furniture, reaction. I had used him for 12 years and trusted him exactly because he never told me what I wanted to hear. He was already at his desk when I arrived at 8. A legal pad in front of him. 2 folders. He had not slept much either. He waited until I sat down before he spoke. "The marriage certificate she presented is not legally valid," he said. "Whitmore never filed for dissolution of your marriage. Not in Alabama, not in Ohio, not in any jurisdiction I can find record of. What Hesse Collier has is a ceremony, a program, photographs, letters. None of it creates lawful spousal standing because the man who stood beside her was already legally married to you." I nodded once. "That matters," he continued, "because probate courts work from legal status, not emotional status. Public record controls inheritance disputes." He opened the second folder. "Now, the child is different. Biological connection gives Stellan potential standing as a direct heir. The court can recognize him as Whitmore's son if paternity is established. But inheritance rights attach only to Whitmore's actual net estate, after obligations, taxes, liens, and creditor claims are addressed." He slid several pages across the desk toward me. "Which, based on what you've brought me," he said carefully, "is considerably less than she believes." He walked me through everything methodically. The creditor claims already filed against the company. The IRS obligation. Whitmore had been pushing forward through extensions and partial compliance, vendor disputes that had escalated toward litigation, liens attached to both properties, one equipment financing default tied to vehicles the company no longer even operated. No theatrics, no dramatic pauses, just numbers. I appreciated that. "You can fight this on every front and win," he said finally. "Her standing as a spouse doesn't exist legally. The child's claim is real, but financially limited because the estate itself is distressed. Your position as legal wife is unambiguous. We file a formal response. We challenge standing. We force full review of liabilities before any transfer discussion even begins." He set his pen down. "Elowin, you have everything you need to end this quickly." I looked at the folders on his desk. At the legal pad where he had outlined a strategy I had no doubt would work exactly as he described. Then I looked up at him. "What happens if I don't fight?" He went still. I'm sorry? If I don't contest the claim? If I don't challenge her filings immediately? What happens if I simply let them pursue the estate? Oswald leaned back slowly in his chair. I watched him process the question in real time, not confused exactly, but recalculating. Elowen, he said carefully, that depends on what you're asking. I'm asking a legal question. He held my eyes a moment longer before answering. If a beneficiary knowingly accepts transfer of a distressed estate or business entity, they also accept the obligations attached to those assets unless the court structures protections around specific portions. Debt doesn't disappear because ownership changes. The creditor claims transfer too. Yes. The tax exposure. Yes. The liens. Yes. I nodded once. Oswald studied me closely now. Any competent attorney representing them would normally conduct full liability review before advising acceptance, he said. Particularly where a minor beneficiary is involved, the court would also appoint independent review before final execution of any transfer affecting the child. I understand. Do you? His voice was quieter now. Because once disclosure enters the record, this stops being about inheritance and starts becoming about exposure. No serious probate attorney wants their client inheriting a collapsing estate unless they believe there's protected value underneath it. I sat with that. Then I asked the question I actually came there to ask. If someone walked into this believing Whitmore left wealth instead of debt, and they pushed aggressively enough before seeing the full structure, could that momentum work against them later? Oswald looked at me for a long moment. Very slowly, I watched him understand what I was really asking. Not grief, not surrender, strategy. He folded his hands together. It could, he said carefully, depending on how far they committed themselves procedurally before full review. I picked up my bag. I need the complete picture, I said. Every obligation, every pending claim, every exposure tied to Whitmore's name, the company, the properties, everything. Elowen? Friday. I stood before he could say anything else. Behind me, I could feel him still sitting there, trying to decide whether the woman walking out of his office was breaking down quietly or beginning to calculate. Oswald called Friday morning at 7:45. He said, "Come in at 9. His voice had the specific flatness of a man who has spent 2 days looking at numbers he wishes he hadn't found. I was already dressed. He had everything laid out when I arrived. Not 2 folders this time, 5. Spread across the conference table in the order he wanted me to understand them. He walked me through each one without preamble. The company first. 3 active creditor claims already filed, vendors. Whitmore had been managing with partial payments and promises long enough that 2 of them had retained their own attorneys. An IRS obligation sitting at a figure that had been accumulating penalties for 22 months because Whitmore had been filing extensions and then not following through. A equipment lease default on 2 commercial vehicles the company no longer operated but was still contractually bound to. Then the estate. 2 properties with liens. The lake house Whitmore inherited from his father and a commercial lot he purchased 7 years ago that had never been developed. Both carrying debt that exceeded their current assessed value. Oswald set his pen down when he finished. The number he wrote at the bottom of the legal pad was not a number I had prepared for even after everything I had already found. It sat on that page like something physical, like weight. I looked at it for a long time. Then I looked at the window. I thought about the morning 3 weeks ago. Before the funeral. Before Hesse. Before any of this had a shape. When I sat at my kitchen table and made the decision to cover it. To use Pruitt Facilities Solutions to absorb what Whitmore left behind. I had built that company from nothing. 14 contracts in the first year. 41 in the third. A reputation built on showing up when other companies didn't and delivering what I promised without being asked twice. I had been willing to put all of it behind his debt. I looked at the number on the legal pad again. Then I thought about my company's last quarterly report. Clean, profitable, growing at a rate I had worked 22 years to achieve. Contracts in 3 counties. A staff of 31 people whose livelihoods ran through payroll I signed every 2 weeks. 2 different worlds sitting on the same table. One I had built with my hands and my judgment over 2 decades. One he had inherited and quietly dismantled over 9 years to fund a life I knew nothing about. I had been prepared to sacrifice the first one to save the second. That preparation felt different now. Not noble, not responsible. Expensive in a way I had not fully calculated until this moment. I looked at Oswald. If someone accepted this estate voluntarily, I said, fully informed or not, would they be legally responsible for everything attached to it? He looked at me carefully. We had covered this ground on Wednesday, but he understood I was not repeating myself. I was confirming something. Closing a door I had been standing in front of for 3 days. Yes, he said. Everything transfers with acceptance, the assets and every obligation attached to them. I nodded. I looked at the number one more time. Then I closed the folder over it. I picked up my bag. I thanked him. I walked out of his office and stood at the elevator and waited. The decision wasn't made in that room. It had been made somewhere between the number on his legal pad and the memory of 31 people whose names were on my payroll. I just hadn't said it out loud yet. The formal filing arrived through Oswald on Monday morning. He forwarded it without commentary, which was his way of letting the document speak before he did. I read it at my desk at Pruitt Facilities Solutions. My office, my building. The place I came when I needed to think without the weight of that house pressing down on me. The filing was thorough. Hesse's attorney, a man named Dale Rutherford based out of Columbus, had constructed the claim around Stellan almost entirely. The language was careful and deliberate. Words like rightful heir and biological legacy and a child left without his father appeared in the first 2 paragraphs. Whitmore's name was followed every time by the phrase Stellan's father, not husband, not deceased, Stellan's father. Rutherford knew exactly what he was doing. Probate judges are still people before they are judges. A child standing at the center of a filing changes the emotional temperature of a room before anyone reaches the financial pages, especially in a case already attracting attention. Whitmore's family name carried weight locally long before I married into it. His father sat on 2 regional development boards in the 90s. Their company handled industrial maintenance contracts tied to several visible commercial properties around Birmingham for years before Whitmore inherited it. Then there was me. Pruitt Facilities Solutions had managed municipal and commercial contracts across 3 counties for over a decade. City buildings, school maintenance, county facilities. People knew our names whether they knew us personally or not. And Birmingham is still small enough in certain circles that people notice when recognizable families crack open publicly, especially when there is a child involved. The first article appeared through Birmingham Tribune Online less than 24 hours after the filing entered public access. A local outlet, mostly business news, civic disputes, and courthouse reporting. The kind of publication radio hosts quote during morning traffic segments and church women share in private Facebook groups before noon. By the second repost, it stopped being a probate filing and became a story. Every line in Rutherford's filing was written for readers who had never met Hesse Collier. Every sentence pushed the same idea quietly and repeatedly: a grieving child being denied what belongs to him. I set the document down. I thought about Stellan sitting at my table. The way he looked at Whitmore's photograph on the side table and stayed on it 1 second longer than everything else. A 6-year-old boy who had lost his father and had no understanding of what the adults around him were building in his name. He was not strategy. He was a child. His mother had built a legal argument around his grief and his biology and his face, and she was not wrong that those things were real. She was simply using real things for calculated purposes and calling it justice. I understood the difference. I did not call Oswald immediately. I sat with the filing for nearly 40 minutes and read it twice more. I wanted to understand exactly how Rutherford intended to move this through probate court before full financial review slowed him down. Because that was the first edge I found. The filing emphasized inheritance aggressively while barely acknowledging liability exposure beyond standard disclosure language. Rutherford was positioning the case emotionally first, pushing beneficiary recognition and estate access before the full debt structure became the center of discussion. That told me something important. He believed there was value underneath Whitmore's name worth rushing toward. And maybe Hesse believed it too. By the time Oswald called that afternoon, I had identified 3 places where confidence had made Rutherford less careful than he should have been. "I've read it," I said when I picked up. "There's something else," he said. His tone had flattened slightly. The particular flatness he used when news required preparation before delivery. Hesse Collier gave a statement to Birmingham Tribune Online this morning. The article's already circulating locally. I leaned back slowly in my chair. What did she say? That she's trying to protect her son's future from being blocked by Whitmore's legal wife. Legal wife. Interesting phrasing from a woman who believed she had been married herself. Photograph 2, Oswald continued. Courthouse steps. Child beside her. I closed my eyes briefly. A 6-year-old boy's face attached to a probate strategy before he was old enough to understand what probate meant. The anger moved through me cleanly, and then settled. Not at the child. Never at the child. At the calculation of a woman who understood exactly what people would emotionally attach themselves to if given the opportunity. "Let it run," I said. "Don't respond publicly. Don't issue anything." "Understood." A pause. "There's one more thing." I waited. "A woman contacted my office this morning. Not Hesse Collier. Someone else." Something in his tone shifted slightly on the last 2 words. "She says she also had a relationship with Whitmore. 4 years. She claims he presented himself as separated." The room became very still around me. "Does she want money?" I asked. "No." That answer surprised me enough that I said nothing. Oswald continued. "She says she has documentation, messages, financial records, travel confirmations. She believes some of the transfers overlap with the accounting irregularities you identified last week." I sat back slowly in my chair. Not another affair, a pattern. And patterns once established become evidence of intent. The second woman's existence sat in me overnight like a stone in still water. Present, heavy, but not destabilizing. I had already redrawn my understanding of who Whitmore was. One outside family had required that redrawing. A second woman required nothing new. She was simply confirmation of a pattern I had already mapped. I filed her away and kept moving. The calls started Tuesday. My operations manager at Pruitt reached out first, carefully, professionally, asking if I needed anything without saying what he had read. Then, my accountant. Then 3 women from my church circle within the same afternoon, each one beginning with, "How are you doing, baby?" in a tone that meant I saw the news. I answered every call the same way. I was fine. I appreciated them reaching out. I would be in touch. By Wednesday evening, I had stopped answering and was returning calls in batches from my office where I could keep my voice level without the house around me making it harder. Thursday morning, Clarice Dunmore did not call. She knocked. I heard her at the front door at 9:15, and I knew before I opened it that this conversation would be different from the others. Clarice had known me since I was 23 years old. She had sat in the front pew at my wedding. She had brought food to this house after Whitmore's funeral without being asked, and left without making me talk. She was not a woman who said things for the sake of saying them. I let her in. We sat at the kitchen table, the same table where Hessie had laid out her folder 8 days ago. Clarice folded her hands and looked at me directly. "People are talking, Elowen," she said. "They're saying you've given up, that you're letting that woman walk away with everything Whitmore left you. I've heard the word crazy used by people who love you." I looked at her hands on the table. "I know what people are saying," I said. "Then tell me it isn't true. Tell me Oswald has a plan and you're fighting this properly." "Oswald has everything he needs," I said. Which was true, just not in the way she meant it. Clarice studied my face for a long moment. She was looking for something that would reassure her. I kept my expression steady and gave her nothing she could read clearly. Not because I didn't trust her, but because the plan required silence, and silence had to be total. "You work too hard," she said finally. Her voice had dropped. Less community concern now. Just a woman who had watched me build something over 20 years, speaking directly to what she was afraid of. "Don't let grief make you give away what's yours." "I won't," I said. She left 15 minutes later, still worried. I watched her car pull away from the window and felt the specific weight of being loved by someone who couldn't be told the truth yet. I pulled up the Tribune article on my phone. Hessie's photograph, Stellan beside her on courthouse steps. Her expression composed for the camera in the way I had come to recognize. The performance of a woman who needed the public to witness her winning. She had given 2 more statements since Monday. A radio interview. A community forum post that was being shared. Everything she did was designed to be seen. I had not issued one word publicly. Not one. I set the phone down, picked it back up. I called Oswald. "I'm ready to tell you the full plan," I said. The second woman's name was Renata. She asked to meet at a coffee shop on the south side of Birmingham. Neutral ground, her suggestion, which told me she had thought carefully about the dynamics of this conversation before requesting it. She was younger than I expected, early 40s, composed in the way of someone holding themselves together through deliberate effort rather than genuine calm. She was already seated when I arrived, and she stood briefly when she saw me, a reflex of respect that I noticed and said nothing about. We did not spend time on pleasantries. "I saw the news coverage," she said. "I'm not here to make your situation harder. I want you to know that." "Why are you here?" I asked. She wrapped both hands around her coffee cup. "Because he told me the same things he told her," she said quietly. "And because I think you're about to discover he wasn't just lying emotionally. He was lying financially too." That got my attention in a different way. I looked at her steadily. "Go ahead." She had been involved with Whitmore for 4 years. They met through a professional contact tied to commercial property management outside Montgomery. He presented himself as a man trapped in a marriage that had ended emotionally years earlier, a wife who cared more about contracts and expansion than connection, a household running on routine instead of affection. He used my name, Elowen. He said it with the specific exhaustion of a man trying to make betrayal sound reasonable. She had felt sorry for him. I sat with that image for a moment, Whitmore across dinner tables and hotel bars building me into a justification. The difficult wife, the emotionally absent one, the burden he carried honorably while taking comfort elsewhere. He had turned me into a supporting character in stories designed to excuse him. But Renata had not come only to confess an affair. 3 months before Whitmore died, she said, he began talking differently about money. Nervous, watching his phone constantly, taking calls outside rooms, complaining about pressure from vendors and tax notices. Once, only once, he made a comment that stayed with her afterward. "If Elowen ever sees the full books, she'll walk." I said nothing. Renata reached into her bag carefully and slid a thin envelope across the table. "I know you said, through your attorney, you weren't looking for scandal," she said. "This isn't scandal." Inside were copies, hotel confirmations, travel records, screenshots of transfers Whitmore sent her during periods he claimed he was waiting on delayed vendor payments. The amounts were not enormous individually, but they overlapped precisely with several irregular withdrawals I had already identified in company accounting. Not just affairs, diversion patterns. "He used business instability as an excuse with me too," Renata said quietly. "Said he was stuck carrying everyone financially. Said people depended on him. But toward the end..." She hesitated briefly. "Toward the end, he sounded scared, not guilty. Scared." I looked down at the documents again. Dates, amounts, patterns. What Renata handed me would not destroy Whitmore publicly. It was not criminal revelation, not dramatic exposure, but it did something more important. It established continuity. A long-term behavioral pattern tying emotional deception directly to financial concealment. And patterns matter in courtrooms because patterns suggest intent. "He told you the marriage was over?" I asked. "Functionally, yes." "And you believed him?" "At first." The honesty in that answer mattered more to me than if she had tried defending herself. Renata had no ceremony photographs, no child, no legal standing. She had contacted Oswald because once the Tribune story broke, she realized she might not be the only woman Whitmore had lied to. She withdrew any request for involvement before the meeting ended. Quietly, no performance, no tears, no attempt to place herself at the center of anything. I believed her when she said she wanted nothing except for me to have the truth before the hearing moved any further. She left first. I stayed at the table for several minutes after she was gone. I did not grieve Whitmore in that coffee shop. That grief had already changed shape. What sat in me now was something quieter and more permanent. I grieved the woman he had turned me into when I wasn't present to defend myself. The cold wife, the difficult one, the explanation. I had spent days preparing to absorb his debt before anyone knocked on my door claiming inheritance rights. I had been willing to use my own company's reserves to clean up what he left behind. And somewhere across Alabama and Ohio, Whitmore had been using my loyalty as camouflage. That was the part that cost me the most. I drove back to my office, sat at my desk, opened my laptop. I created a new document. In the subject line, I typed 4 words. "Here is what we are going to do." Then I began. Oswald read the document I sent him the night before without interrupting it with a call. That was deliberate on my part. I needed him to sit with the full structure before he reacted to any single piece of it. When he finally called Friday morning, his voice carried the particular quality of a man who had spent several hours recalculating assumptions he no longer trusted. "Come in," he said. I was already in the car. He was standing when I arrived, not seated behind his desk, but at the window with the document printed in his hand. 3 pages, single-spaced. I had written it the same way I ran my business. No unnecessary language, every step in operational order. I sat down. He remained standing for another moment before finally taking his chair. "Walk me through it," he said, out loud. I nodded. The estate transfer acknowledges Stellan directly, not Hesse, him. His biological connection to Whitmore is the only legally supportable claim in this proceeding, and I'm recognizing it voluntarily before the court has to force the issue. Oswald made a note. "That matters because it removes any appearance that I'm trying to deny the child inheritance rights out of personal hostility. The court sees cooperation instead of obstruction. Another note. Because Stellan is a minor, no transfer can finalize without guardian ad litem review and probate oversight. The guardian isn't chosen by Hesse. They're appointed independently, and their legal obligation is to the child's financial protection. Oswald nodded once for me to continue. The estate disclosure package stays attached in full from the beginning. No concealed liabilities, no withheld debt schedules. Every lien, every creditor action, every IRS obligation, every equipment default, every pending exposure attached simultaneously to the transfer proposal. I watched him carefully as I continued. The important distinction is timing. That made him look up. Rutherford is approaching this like a beneficiary recognition fight first and a liability review second. He's moving aggressively to establish emotional and procedural momentum around Stellan before the financial structure fully slows the case down. That creates pressure to secure the inheritance position quickly before public sympathy changes direction. Oswald leaned back slightly. I continued. The disclosure isn't hidden. It enters the record exactly where required. But by the time Rutherford fully pivots into asset versus liability analysis, he has already committed publicly and procedurally to the narrative that this estate contains meaningful value worth pursuing. And you believe he'll overcommit to that position, Oswald said quietly. I think Hesse already has. The room went still for a moment. Hesse has no legal spousal standing, I said. The marriage certificate collapses under public record review. Once that happens, every aggressive filing Rutherford made on her behalf becomes dependent almost entirely on Stellan's inheritance rights. And the estate itself. Exactly. I folded my hands together. The court-appointed guardian becomes the stabilizing mechanism for the child. Creditors process first. Probate administration follows standard order. Whatever survives after obligations are satisfied gets structured appropriately for him. That may not be much, but I'm not interested in destroying a 6-year-old boy to punish his mother. Oswald studied me quietly. You've thought through every procedural angle. I've had time. He looked back down at the document, turned to the second page, read a section he had already read once before. I watched him work through it the way he worked through everything. Slowly. Looking for the fracture point. The exposure. The thing opposing counsel might use to unwind the structure later. Finally, he set the pages down. This is legally executable, he said. The disclosure structure is compliant. The guardian requirement protects the court procedurally. The transfer proposal itself is clean. He paused. But there are risks. I know. If Rutherford requests extended forensic review before acceptance, momentum slows. He won't at first. You sound certain. He went public too early. That answer sat between us for a moment. Oswald folded his hands carefully. You understand something else, he said. Once this enters motion, there is no returning to your original position. Whatever remains in that estate after creditor administration, if anything remains, stops belonging to you completely. I looked at him evenly. I know. And if Hesse realizes what the estate actually is before final commitment, then she'll spend the rest of the proceeding trying to back away from cameras and statements she already made publicly. Oswald said nothing. Neither did I. After a long moment, he leaned back in his chair and exhaled once through his nose. For the first time since Whitmore died, he was no longer looking at me like a grieving widow. He was looking at me like a strategist. I'm not planning to come back, I said quietly. I stayed at the office until nearly 10, not because there was work left that required it. The contracts were reviewed. The accounts were current. The expansion proposal I had been deferring for 8 months was outlined and sitting in a folder marked for next week. Everything on my side of this life was in order the way it had always been in order, because I had built it that way deliberately, because order was the thing I controlled when everything else moved without my permission. I stayed because the office was mine. In a way, the house no longer felt like anything. Around 8, I pulled the banker's box from the corner where I had set it 3 days earlier. Whitmore's remaining documents, the last accordion file, the folders I hadn't fully processed, the copies Oswald had returned after discovery review. I had told myself I would do one final pass before the hearing. Walk into tomorrow with nothing unexamined behind me. I worked through it methodically. Vendor correspondence, insurance documents, old board minutes from before Whitmore started moving money between accounts quietly enough to avoid immediate scrutiny. Most of it I had already seen. Then I found it near the bottom of the box. A single bank statement folded into the back of a file marked personal. 1 page. An account I had never seen before, not in the kitchen table review, not during discovery, not in any financial disclosure Whitmore maintained through the company. The balance was modest. Not hidden millions. Not secret wealth. Just enough money to make me stop reading and sit down properly. Small enough that it would never have triggered concern during standard accounting review. No business transfers attached to it. No payroll movement. No creditor activity. But the name on the account was only mine, not joint, not trust-linked. Mine. I sat down slowly. The account had been opened 11 years earlier. Contributions appeared irregularly over roughly 7 years. Small deposits, inconsistent amounts. Nothing large enough individually to draw scrutiny. Anniversary months. 2 deposits within weeks of my mother's funeral. Another, the same year I expanded into Jefferson County. The deposit stopped 4 years ago. The account had remained untouched since then, accumulating modest interest in silence. I held the statement under my desk lamp for a long time. Procedurally, the account was straightforward. Because my name alone sat on it, probate would not pull it into estate administration. Legally, it was already mine, regardless of what happened tomorrow. But emotionally, it disrupted something I had already settled in my head. At some point, for reasons I no longer had access to, Whitmore had quietly set something aside for me. Not enough to redeem him. Not enough to outweigh Ohio or Hesse or Stellan or the years of deception or the financial wreckage sitting behind his name. And definitely not enough to transform him into some misunderstood good man trapped by circumstances. That was important. Because I refused to perform that kind of emotional revisionism, simply because a dead man left behind one contradictory gesture. The account did not erase what he did. It complicated it. That was different. Simple villains are easier to bury. Real people are harder because they leave fragments behind that refuse to fit together cleanly. I looked back through the deposit dates again. Smaller amounts during years when business pressure was highest. 1 note line attached to a transfer from 9 years ago. For later. Nothing else. No explanation. No letter. No coherence. Just evidence that somewhere inside the same man who built a second family and used my name as emotional camouflage, there also existed someone carrying guilt, attachment, obligation, or maybe some version of care he did not know how to express honestly while he was alive. I could not make those pieces fit together neatly. I tried for 20 minutes. Then I stopped trying. Whitmore had not been one thing. He had been several contradictory things simultaneously, and I was never going to untangle all of them into a conclusion that felt emotionally complete. Some people die before becoming understandable. I placed the statement carefully into my bag, closed the banker's box, stacked it beside the office door for pickup Monday morning. Then I turned off my desk lamp and stood there in the dark office with my hand still resting against the switch. It cost me something to leave that room. Not grief, exactly. Grief had already changed shape several chapters ago. This felt different, like finally accepting that there would never be one clean answer waiting at the bottom of Whitmore Pruitt. No final document that explained him completely. No hidden page capable of balancing all the others. Just fragments, some ugly, some human, all incomplete. I locked the office door behind me, walked through the quiet Birmingham parking garage toward my car. The night air had cooled while I was inside. I stood there for a moment with my keys in my hand and looked out across the city lights beyond the structure. Tomorrow, the courtroom would become public record. Tomorrow, Hesse would walk in believing she understood the shape of this story. Tomorrow, I would stop carrying what Whitmore left behind. I looked up into the dark. Tomorrow, I said quietly to no one at all. I put it down. I was dressed by 6:15, not black. I looked at the black dress hanging in the closet and left it there. I chose charcoal trousers, a deep burgundy blouse, and the jacket I wore the day I signed the expansion contract that carried Pruitt Facilities Solutions into its third county. A woman going to work. That was the only frame I needed for today. I arrived at the courthouse at 8:40. The hearing was scheduled for 10. I found a bench outside the assigned courtroom and sat with my hands folded loosely in my lap, and nothing beside me. No briefcase, no performance, no visible grief arranged carefully for strangers. The building filled slowly around me. Other hearings, other families, other attorneys carrying folders thick enough to alter lives. The hallway carried that familiar courthouse atmosphere, anxiety wrapped in politeness, people pretending calm while waiting for systems larger than themselves to make decisions. I had already made mine weeks ago. The stillness that comes after a finished decision settled into my posture naturally. I did not have to force it. At 9:12, my phone buzzed. Clarice Dunmore. I'm praying for you, baby. 5 words. No punctuation after baby. The way Clarice always talked when emotion stripped the formality out of her completely. I looked at the message longer than I meant to. Clarice had spent 30 years showing up for me quietly. Never loudly loyal. Never performative. Just present in the steady, dependable way some women move through other people's lives. She was still worried. She would stay worried until she heard how this ended. I typed back 2 words. Thank you. Then I turned the phone face down on the bench beside me. At 9:27, I heard them before I saw them. The sound of multiple people walking with coordinated purpose through a courthouse hallway. Firm footsteps, a rolling briefcase, the particular pace of people who believe momentum already belongs to them. I looked up. Hesse entered from the far end of the corridor, wearing a structured ivory coat, chosen carefully enough that I knew she spent time deciding on it. Stellan walked beside her in a pressed dark jacket, quiet as always. Dale Rutherford followed half a step behind, carrying his briefcase with the posture of an attorney already mentally drafting post-hearing statements. I watched them move toward the courtroom. Hesse saw me almost immediately. She did not look away. Neither did I. We held eye contact for 2 full seconds. 2 women connected permanently by a man no longer alive to explain himself. And then she turned forward again and continued walking. What I felt watching her was not triumph, not anger either. Something quieter than both. Because somewhere underneath everything else, Hesse still believed she was walking toward security, toward rescue, toward the thing Whitmore promised existed on the other side of all this. That belief made her more human to me than I wanted it to. Oswald arrived at 9:35 and sat beside me. He looked first at my empty hands, then at my face. "Last opportunity," he said quietly. "Once we walk inside and the disclosures formally enter review, the tone of this proceeding changes permanently." I looked straight ahead. "Do you think Rutherford understands yet?" I asked. "No," Oswald said. "I think he understands there are liabilities. I don't think he understands the scale." I nodded once. "And Hesse?" His silence answered before the words did. "No," he said finally. The courtroom doors opened briefly as the earlier matter concluded. Attorneys exited first. Then a family speaking too quietly to hear. Oswald adjusted the cuff of his sleeve. "If Rutherford requests extended continuance after reviewing the full schedules, Judge Carroll will probably grant limited review time before final execution," he said. "But the public filings, the debt schedules, the standing issues, those are all entering record today, regardless." "I know." He looked at me carefully then, not like an attorney studying a client, like a man still trying to decide whether what I was about to do was mercy or strategy. Maybe it was both. The bailiff stepped into the hallway and called our case. I stood, straightened my jacket, picked up nothing because there was nothing to carry. No folders, no paperwork, no rehearsed statement waiting for the right dramatic moment. Everything I needed for today had already been carried into this building before I ever walked through security. The decision, that was all. The courtroom was smaller than I expected for the weight of what was happening inside it. Judge Aldine Carroll presided, late 50s, economical in her movements, the kind of woman who had spent years watching families turn grief into litigation, and no longer confused emotional volume with legal substance. She reviewed the transfer packet Oswald submitted without visible reaction, turned pages, made one notation, set her pen down. Rutherford sat across the aisle with Hesse beside him and Stellan directly behind the bar. The boy sat perfectly still with both hands on his knees, looking into the middle distance the way children do when they've been told today is important without being told why. I noticed Rutherford had brought an additional associate this time. Younger, probably local counsel. They had 2 bankers' boxes positioned beside their table and a yellow legal pad already divided into sections, which meant one important thing immediately. He had reviewed enough of the disclosures to understand the estate was complicated. Good. That mattered for realism more than surprise ever could. Because no competent probate attorney reaches a hearing involving multiple businesses, municipal visibility, interstate inheritance claims, and attached disclosures without expecting financial complexity somewhere inside the file. But expecting complexity and understanding scale are 2 different things entirely. Judge Carroll looked toward both attorneys. "The court has reviewed the proposed transfer framework," she said. "Biological recognition appears sufficiently documented for provisional inheritance standing pending final verification. The disclosure schedules and liability statements have been attached pursuant to probate procedure." She looked directly at Rutherford. "Counsel has received the complete packet including debt disclosures, creditor actions, tax exposure summaries, pending encumbrances, and the supplemental accounting schedules submitted Friday?" "We have, Your Honor." This time, I watched more carefully. Rutherford did not answer recklessly. He answered like a lawyer managing procedural momentum inside a hearing that was never intended to complete forensic administration today. That distinction mattered. He had likely reviewed the primary disclosures already: creditor actions, tax exposure, liens, and probate liabilities. What he had not fully absorbed yet was how aggressively those liabilities consumed the estate once layered together operationally. There is a difference between a distressed estate and an estate with almost no protected value remaining underneath the distress. He still believed he was dealing with the first category. Judge Carroll continued. This hearing does not finalize creditor disposition or probate closure. Today's purpose is limited to establishing whether the proposed transfer framework may proceed subject to continued review, guardian oversight, and statutory administration. That mattered too, because hearings like this often move in stages. Preliminary recognition first, administrative review second, full creditor and asset reconciliation afterward. Rutherford still believed there was enough value inside Whitmore's holdings to justify continuing forward through that process. The judge turned toward Oswald. "We'll proceed with execution of the provisional transfer documents." Oswald slid the document set in front of me. I picked up the pen. The first signature line sat beneath the voluntary beneficiary recognition clause. I signed without rushing. My full legal name, deliberate and clean. The same signature I had used on contracts that built everything I actually owned. I could feel Hessie watching my hand. She sat slightly forward in her chair, ivory coat perfectly arranged, fingers folded together with the careful composure of a woman who had rehearsed this moment repeatedly in her head. Second signature. Third. The room carried a very particular stillness now, the kind that settles over people who believe the emotional outcome has already been decided and are merely waiting for paperwork to formalize it. I felt the room leaning toward Hessie, toward Stellan, toward the narrative Rutherford had spent weeks building publicly. I signed the final line. Oswald collected the documents and handed the full packet back to the bench. Judge Carroll reviewed the signatures, initialed the procedural acknowledgement page, then passed the acceptance materials across to Rutherford for receiving party review and provisional countersignature consideration. Not final victory, not completed transfer, but formal procedural advancement moving the estate administration forward. Rutherford took the packet confidently. That confidence mattered more than speed ever could have. Because the problem was never that he ignored the disclosures completely. The problem was that he believed the disclosures described negotiable distress attached to fundamentally valuable holdings. He still thought there was something substantial underneath the damage worth protecting aggressively for his clients. I set the pen down. Behind the bar, Stellan shifted slightly in his seat. Just a small adjustment after sitting still too long. Hessie turned toward me then. The smile on her face was not cruel, not mocking. It was the smile of a woman who believed years of uncertainty had finally tilted in her direction. A woman who had driven 400 miles, hired counsel, stood before cameras, placed her child inside a public legal fight, and arrived at the exact moment she imagined would justify all of it. I looked back at her steadily, and for a second, just one, I saw something underneath the confidence. Relief, not greed. Relief. That almost made it harder. Because whatever else Hessie Collier was, she truly believed Whitmore had left her and Stellan something worth fighting for. She did not yet understand that Whitmore had left everyone the same thing. A collapsing structure disguised as security. Judge Carroll instructed Rutherford to proceed with acknowledgement review before guardian scheduling and further administrative hearings. Rutherford opened the packet again, this time more slowly. I watched him move through the supplemental schedules. Creditor sequencing, cross-collateral obligations, IRS exposure calculations, property assessments against outstanding balances. His associate leaned closer halfway through the second section. The first visible change wasn't panic. It was concentration. Real concentration. The kind that replaces courtroom performance the moment a lawyer realizes the numbers underneath a case may alter the strategy entirely. Rutherford turned back 2 pages. Read something again. Made no note. And for the first time that morning, I watched his expression lose a fraction of certainty. Very small, barely visible. But there. I sat back quietly in my chair and said nothing at all. Rutherford opened the packet with the controlled confidence of a man who believed he was entering the final administrative stage of a victory already secured emotionally weeks ago. He started with the transfer framework, biological recognition language, provisional inheritance structure, guardian review scheduling, estate itemization. His pen moved steadily through the margins, making small procedural notes. Not the notes of a man discovering danger, but of a man confirming structure he already expected to see. Beside him, Hesse sat with both hands folded neatly together on the table. The smile from earlier had softened, but not disappeared. It rested on her face quietly now, the expression of someone finally approaching the end of a long, uncertain road. Behind them, Stellan sat still in his pressed jacket, watching his mother's profile more than the courtroom itself. Rutherford turned the page. The next section outlined operational structures tied to Whitmore's company holdings. Standard probate attachment material. He kept moving. Faster now. His pen still making notes, though fewer than before. Then the pen slowed. Not suddenly. Gradually. The way a car slows when the driver has noticed something ahead but has not fully accepted yet that braking may become necessary. His eyes moved back 2 lines, then back an entire page. He read again. Hesse noticed immediately. I watched the shift happen in her shoulders first. A slight tightening, almost invisible unless you were already paying attention to her body the way I was. Rutherford kept reading. The creditor schedules appeared next. 3 active claims already filed formally against the estate-linked business entities. Outstanding balances attached, filing attorneys listed, collection posture summarized in plain language. His pen stopped moving. He turned another page. IRS obligations. 22 months of accumulated penalties and deferred compliance exposure. The figure at the bottom of that page changed the atmosphere of the courtroom without a single person speaking. The room changed. Not dramatically, quietly. Like temperature dropping. Hesse's smile disappeared completely now. Not slowly. Instantly replaced by the careful blankness of someone trying to understand whether panic is justified before allowing it to surface publicly. Rutherford continued reading. Equipment lease defaults. Property lines exceeding assessed value. Pending vendor actions. Cross-collateral exposure attached to inherited business assets. I watched his posture change 1 fraction at a time. Not incompetence, not stupidity. Calculation collapsing in real time. He had entered this proceeding believing the primary question was how much value could be secured for his client. Now he was discovering the more important question was whether the estate possessed net value at all after administration. Then he reached the certified public record section. Marriage dissolution search. Jurisdiction by jurisdiction. Alabama, Ohio, Georgia, Tennessee, no filing, no divorce, no interruption whatsoever to the legal marriage between Whitmore and me from beginning to end. Rutherford stopped reading. The silence inside the courtroom developed actual weight now. Judge Carroll watched him carefully over folded hands. Not surprised. Just waiting. Rutherford looked down again at the debt schedules, then back to the certified record, then slowly toward Hesse. She searched his face immediately, looking for a door, an explanation, a version of this that still ended with security instead of exposure. But Rutherford no longer had that expression on his face. For the first time since these proceedings began, he looked like a lawyer recalculating risk instead of pursuing advantage. Judge Carroll finally spoke. Counsel, she said evenly, is the receiving party requesting additional review time before countersignature and guardian recommendation scheduling? There it was, the off-ramp. Rutherford did not answer immediately. That hesitation told me everything. Because the problem was no longer legal misunderstanding. The problem was procedural momentum, public filings, press statements, Weeks spent aggressively asserting inheritance rights before full liability analysis had been completed. Backing away now would not erase any of that. Beside him, Hesse said his name quietly, not loudly, worse than loudly, confused. Rutherford leaned toward her and said something too low for me to hear. I stood. I gathered nothing because I had brought nothing with me except the decision already made days earlier. I leaned toward Oswald. "Thank you," I said quietly. Then I picked up my bag and walked toward the courtroom doors at a pace that required no hurry at all. Behind me, I heard Hesse say Rutherford's name a second time, this time sharper. And underneath it, for the first time since she arrived in Birmingham, I heard fear. I did not turn around. I drove directly from the courthouse to my office, not home, not anywhere that required me to sit inside the architecture of a life I had just formally closed. My office. Pruitt Facilities Solutions. The name on the glass door in the same brushed metal lettering I chose years ago, because I wanted it to look like something built to survive. I parked in my usual spot, walked through the front entrance, nodded once to my operations manager at the reception desk without stopping. Then I went into my office and closed the door behind me. I sat down. The desk was the same desk I had been sitting behind for 11 years. The same desk where I reviewed quarterly reports, negotiated contracts, signed payroll approvals, built expansion plans, county by county, without shortcuts and without inheritance carrying me there. The same desk where I had spent weeks preparing to sacrifice my own company to save Whitmore's collapsing one before I finally understood what I was actually protecting. I sat there quietly and let the room settle around me. Somewhere across Birmingham, Hesse Collier was beginning the long procedural process of understanding what had actually happened in that courtroom. Not emotionally, financially. Probate administration would continue, creditor review, guardian oversight, asset evaluation, nothing dramatic. Real consequences almost never arrive dramatically. They arrive in letters, filings, schedules, consultations, revised projections. Rutherford had requested additional review time before countersigning final acceptance. Judge Carroll granted a limited continuance for guardian assessment and liability analysis before any irrevocable transfer execution moved forward. But the important damage had already happened. The public narrative Hesse built, grieving widow denied inheritance, now sat directly beside court record debt schedules, invalid marital standing, IRS exposure, liens, and creditor actions attached to the very estate she had fought publicly to claim. Momentum had turned, not because I embarrassed her, because the paperwork finally caught up to the performance. I did not take pleasure in imagining her sitting with those numbers for the first time. I simply acknowledged it was happening and allowed it to remain at the distance it deserved. I thought about Stellan instead, a 6-year-old boy in a pressed jacket who sat quietly through adult consequences he did not create and could not possibly understand. The guardian ad litem would now move into the center of the process exactly the way I intended. Someone legally obligated to separate the child from the ambitions and mistakes surrounding him as much as possible. I hoped they did. He deserved at least one adult in this story whose loyalty belonged entirely to him. I opened my bag and took out the bank statement again. The small account. My name only. 11 years untouched. I studied it once more in the late afternoon light spilling across my desk. Then I placed it carefully into the top drawer and closed it. I still did not know what it meant. Maybe Whitmore opened it during one of the years he thought about leaving and couldn't. Maybe during one of the years he knew he was failing financially and wanted one untouched thing left behind for me. Maybe guilt. Maybe love. Maybe both. I no longer needed the answer badly enough to destroy myself searching for it. Some people die incomplete. That was the truth of Whitmore Pruitt. I opened my laptop. 3 client meetings next week. A Jefferson County contract renewal waiting since September. The expansion proposal sitting in the folder marked next quarter. 3 additional counties already mapped financially and operationally. 8 months of delay ended today. Outside my office window, Birmingham continued moving through Friday afternoon without understanding anything that had shifted inside that courtroom. Traffic moved, phones rang, contracts got signed, restaurants filled for dinner. Life rarely pauses because your marriage collapses publicly. My phone buzzed once on the desk. Then again, likely reporters this time. Or community gossip finally reversing direction after the court filing details reached public access. I turned the phone face down. Whitmore left behind debt disguised as legacy, and a version of himself I would never fully untangle. Hesse came to Birmingham believing inheritance meant safety. Rutherford walked into court thinking emotion could outrun arithmetic. All of them were chasing appearances. I looked around my office one final time. The contracts, the schedules, the company I built with my own hands. My attorney called what I did strategy. Maybe he was right. But sitting there behind that desk, I realized the simpler truth was this. I finally understood the difference between owning something and merely inheriting the illusion of it.